Good morning, everyone. Welcome to New York Law School. I'm Bill Piana. I am the Dean of Faculty. And as you can see from the program, my academic title now reflects what I spend most of my time doing besides administering. That's dealing with the law of wills and trusts. So when Penny asked me to give the introduction to this wonderful symposium today, I was a little hesitant because it's been many years since I was professionally engaged with the historical studies with which I began my academic career. But I thought that the reflections of an interested amateur would be better than my talking to you about the struggle to create a New York statute governing convenience bank accounts or no contest clauses in wills and trusts. So I will spare you that torture. But I do have a wills and trusts insight to what we're doing today. The most important case the Court of Appeals has ever decided in dealing with how to interpret a testamentary document is called matter of fabric. And in dealing with a will, the court wrote that one must read the document as a whole in the light of all the facts and circumstances that existed when it was created. That, to a great degree, is what not has been done with the 14th Amendment. Professor Graeber's work is trying to repair. How that has happened, I think, is very understandable. That first section has become the objective correlative of the founding promise that we are all equal and possess rights which can't be taken from us. That has led, of course, to the focus on those guarantees of equal protection and due process, which has led to an enormous transformation of our law. But it has also led to an examination of the text, which sometimes I think verges on scriptural exegesis. And whether this is the baleful influence of law on history or history on law is debatable, but I think it's there. But as Professor Graeber points out, we can't understand what's going on without reading the whole thing. And when you read the whole thing, it suddenly dawns on us, I think, that this amendment is much about the political reconstruction of the Union, the reward of loyalty and the punishment of treason, as it is to create a social reconstruction, which certainly was attempted in the aftermath of the war and which has been widely documented, of course. Once we look at that entire picture, we see all the kinds of things that this wonderful book and I'm sure its successful volumes begin to explain to us. I keep thinking that somewhere the shade of Charles' beard is smiling. Follow the money, whose bonds are going to be paid, whose debts will be discharged, and who will be taxed to do that. All of that is there, and all of that is something I think to which we have not given enough thought in 150 years. And when we look at this thing as a whole, as trying to reconstruct the Union politically as well as socially, and far more the former perhaps than the latter, 1877 makes a lot more sense. It's a lot easier to understand. And it drives us still to trying to consider the endless attempts of the Republic to deal with racial equality, with the attempts to structure a society in which people are not put in boxes based on how they look, a struggle with which continues, of course, to today. And I don't want to end on too depressing a note, which is difficult in this day and age. But one conclusion one can draw, I think, and in the end, power prevails. We may believe that we want to have power in order to do what we consider to be good things, in which we think, in fact, posterity will judge to be good things. But what is good can be terribly subjective and open to endless redefinition. There's something very poignant about senators complaining that we created your state to make sure we would have senators of our party, and you sold yourself out for the profits of silver mining. Sometimes the lessons of history are very bitter, as well as being very inspiring. I hope that I am now the low point of this day and that we will look up from here, but I thank you all for being here. I congratulate Professor Graber on a terrific piece of work, and I certainly look forward to the subsequent volumes. I have just a bit of housekeeping. There will be what Professor Andrews so beautifully describes as morning tea, coffee, and pastries, which will arrive just in time for the 11 a.m. break. Lunch is in the faculty commons. If you walk straight ahead, jog right, jog left, it will be the second door on your left. And finally, we have 4 student fellows of our Wilf Impact Center who will help guide you through the day. If you have questions, we'll introduce them a little later when they're all here, but they will be here to help you navigate the building and answer your questions. So again, thank you for being here. Thank you for your attention, and I hope everyone finds this a both enlightening and thought-provoking day. Thank you.
We're on. Do you want to have the applicant first? Happy off just two guys.
She said in the middle.
Might make sense for me to go first.
Okay.
Now,
we've done that.
So I think Rebecca makes sense.
Yep, that's fine.
Kind of laying out a little.
I think it's fine. And then me, and then.
All right, that's
Okay.
perfect.
So 15 minutes.
Yeah,
and
of
then-
course.
Keep going.
I didn't say anything. Okay, good morning. We're ready for our first panel. My name is Rick Marsico. I'm here from New York Law School. Welcome our affiliates, who I guess will be introduced later, but thank you both for coming.
I'm sorry, I don't think the mic is on, and I do need it back here.
How about that?
Thank you.
Okay, so again, welcome everyone. I'm Rick Marsico, a professor here at New York Law School, moderating this first panel. The order of our speakers will go essentially left to right. I'll just leave it to you guys to introduce yourselves.
Okay.
We'll go for 15 minutes each, and then we'll have questions.
And you're going to time us because I.
I'll time you.
You can take some of my.
Hi, I'm Rebecca Zietlow. I'm excited to be talking about Mark's great book, which I truly enjoyed reading so much, and actually all of Mark's work, which has really informed my work and the work of so many others over all these years. How do you bring back together a nation that has been ripped apart by a civil war? Listening to the talk about Rudy's book yesterday really highlights the challenge. The war was over an institution essential to the economy of one side of the conflict that was justified by the brutal ideology of white supremacy. People on both sides hated people on the other side. But the side that lost, the South, the Confederacy, resented the loss and the military occupation and felt like they were the victims. They resented and bitterly hated the formerly enslaved people who benefited from the Union victory, hatred that was amplified by racism. And even after the war was over, the former rebels were engaging in vicious violence against the formerly enslaved people. As revealed by the Schertz reports that were on the minds of the members of the Reconstruction Congress as they debated the 14th Amendment, and Mark does a great job of highlighting that. The violence of the time that these Reconstruction debates were occurring. That was the task of the Reconstruction Congress, not only to free the enslaved people and constitutionalize fundamental human rights, but to ensure the continuing existence of the Union in a way that would enable the protection of those rights. The 13th Amendment had abolished slavery, and most members of the Reconstruction Congress believed that it established fundamental human rights to the newly freed slave, including citizenship rights, civil rights, and the equal protection of the laws that were eventually also laid out in the 14th Amendment. But the 13th Amendment also sowed the seeds of its own demise by amplifying the political power of the rebel states. Formerly enslaved people would now be counted as full persons, not 3/5 of a person as before, which was obviously degrading from a human rights perspective, but also had reduced the political power of the slave states. Now they would have more power because the formerly enslaved people would be counted as a full person for apportioning representation. There was a very real danger that rebels, in fact, it wasn't just a danger, it was a certainty that eventually the rebel states, the Democrats would take over the government again. And there was a very danger that the rebel states would do that, the oligarchy that was the slave power once more ascendant. Abolishing slavery ended the entire basis for the Southern economy and cost the former slaveholders hundreds of millions of dollars in today's, if adjusted for inflation. Yet Lincoln and his allies always insisted that secession had no legal effect and rebellious states were part of the Union. After the war, they were to be readmitted into our democratic system. The fear of this was that Southern Democrats would form an alliance with Northern Democrats to undermine the Union victory, reinstating slavery in all but name, repudiating the Northern debt, sinking the U.S. economy, paying off the rebel debt, and compensating former slaveholders for their loss of wealth. And as I mentioned before, in fact, the ascendance of the Democrats to power was inevitable due to demographics. We could call this maybe a constitutional tragedy. That's sort of the theme of today, I fear. There was a very real danger that, I already said that. Okay. Worse yet, the former rebels were still rebellious. They hated the Union that had militarily defeated them. They were not apologetic. They elected former Confederate officers to state office. They tried to elect them to federal office as well. But President Johnson, as Mark describes, and Northern Democrats pretended that rebels had gotten over the war and were newly loyal to the United States. And they ignored the vicious violence and denial of the human rights of the formerly enslaved people. Now, constitutional lawyers tend to focus on the rights provision of the Reconstruction Amendments, especially Section 1 of the 14th Amendment, with the equal protection, due process, privileges or immunities clause. But according to Graeber, those lawyers overlooked the true meaning and import of the 14th Amendment, that it constitutionalized a political strategy to implement the 13th Amendment and protect the Union in the face of continued rebel resistance. Constitutional politics, not constitutional law, were essential to restoring the Union, maintaining the abolition of slavery, and protecting the formerly enslaved people and their loyal white allies. Graeber argues that members of the Reconstruction Congress feared that the 13th Amendment would serve as a mere parchment barrier unless it was enforced by people who had been loyal to the Union and supported its mission of freedom, and that it was, at the time, members of the Republican Party. They were skeptical of rights provisions, and their skepticism was reminiscent of Madison's initial skepticism of the Bill of Rights. Madison, as I'm sure everyone here knows, believed that structural provisions in the Constitution establishing separation of powers and federalism would better protect rights by limiting the power of government. Similarly, as Graeber describes, Thaddeus Stevens and his allies believed that without the structural protections eventually enshrined in sections 2, 3, and 4 of the 14th Amendment, that the guarantee of human rights in the 13th Amendment would not be protected. They sought to punish treason by preventing disloyal people from voting or running for office, eventually codified in sections 2 and 3 of the 14th Amendment, and preventing the rebels from either repudiating the Union debt or paying the rebel debt, codified in section 4. Members of the Reconstruction Congress also sought to reward loyalty by enfranchising formerly enslaved men and white Southern loyalists, and that was the focus of Section 2 of the 14th Amendment. They also at the same time protected the physical safety of formerly enslaved people and loyal white Republicans by continuing to station troops in the rebel states. And they prohibited rebel states from re-entering the Union if they did not ratify the 14th Amendment and prove that they were loyal to the United States, and protected the financial interests of Union supporters, who were primarily white, especially creditors who loaned money to the Union. Thus, they created structural protections for the Union, which would ensure that future political actors would promote the same values, from paying the Union debt to protecting the rights of the freed people that the Reconstruction Republicans shared if those provisions had been enforced. Now, as I mentioned before, Graeber describes the brutal violence from formerly enslaved people, and it's really impossible to understand the events that Graeber describes without comprehending the centrality of racism and white supremacy to the rebel cause that Stevens and his allies so abhorred. Race played a crucial role in determining loyalty, and attitudes towards race very much define views on the future of a post-war nation. At issue was the question of whether the Union would become a nation governed by the ideology of white supremacy, as both Southern and Northern Democrats advocated, or reconstituted as a republic characterized by equal citizenship. After all, formerly enslaved people and free Black people valued voting rights and all their rights, not only for voting rights, not only for instrumental reasons, but so government would adopt policies favorable to them, but also for dignitary reasons. Formerly enslaved people and free Black people brought petitions to the Reconstruction Congress, asking to be treated as equal citizens with economic and political rights. Formerly enslaved people were begging for military protection of their rights. They viewed civil, political, and economic rights as interconnected. They valued not only rights, but the right to have rights. Equal citizenship for formerly enslaved peoples was a combination of years of activism of free Black activists and their white anti-slavery allies, many of whom took up arms to support the Union, along with formerly enslaved volunteers. After the war, some of those soldiers themselves engaged in politics during the Reconstruction era. Now, one way to read Graeber's book is to view the members of the Reconstruction Congress, such as Thaddeus Stevens and Charles Sumner, who led the effort to punish treason and reward loyalty, as unprincipled, power-hungry politicians. However, it would be a mistake to view them in that light, and I don't believe that's what Graeber is, and I know that that's not what Graeber intended. Stevens, Sumner, and their allies sought political power for a reason. They truly believed that maintaining the Union without slavery would only happen due to political reforms. It's no coincidence that Stevens and Sumner, the strongest proponents of maintaining Republican power, were among the members of the Reconstruction Congress who most strongly believed in racial equality. The need for structural protections of the 14th Amendment is especially pressing right now, as we see our country being torn apart over the same issues that plagued our country during the Reconstruction era. The lost cause narrative persists, as does the rhetoric of white male victimhood. And the brutal violence against non-white people in this country, now the principal example that we're seeing on the news every night, of course, is ICE agent attacks against people with dark skin in our cities and throughout our country, by a president who instigated an armed insurrection against the US government after he lost the election in 2020. Ultimately and ironically, sections 2 to 4 became parchment barriers, never enforced by any branch of government. Most tragically, the former rebel states brutally suppressed the vote of formerly enslaved people and their descendants, but section 2 was never enforced against them, and the representation of those states never reduced. Last year, some state officials sought to enforce Section 3, and Mark was involved in this effort, against the presidential candidacy of Donald Trump based on his involvement in the violent attempt to overthrow the presidential election on January 6, 2021. But they were thwarted by the US Supreme Court, and now we see the results. Section 4 has been completely ignored. That's the section that makes it unconstitutional to repudiate the US debt. Arguably, this whole shutdown and all the threats are unconstitutional under Section 4. but that's never been enforced. Sadly, the structural protections by the 14th Amendment were insufficient to ensure the transition of our country from one torn apart by war and racial prejudice to one where slavery was outlawed and the rights of formerly enslaved people and all people in this country were protected. Other structural provisions, and I'm looking at Sandy now, including the composition of the US Senate and the Electoral College, have enabled the perpetuation of the lost cause, white victimhood, white supremacy, and violence against people of color that plagued the Reconstruction era. As we move forward in the future, and someday, I hope, emerge from this Trump era, we will need new structural changes to our Constitution to protect our rights. We need constitutional politics, not only to enforce our constitutional rights, but to protect and maintain our democracy. The members of the Reconstruction Congress knew this, and they gave us tools and strategy to use today. Thank you.
Hey, everyone. Let me begin by just telling you what I love about the book, about the theory behind the book, and about the series. So what I particularly love about the book, I could yell louder for you, just for you. What I particularly love about the book is the idea that what are constitutions for? Constitutions are to structure political competition. And that means that the best way to create the kind of republic you want to create is to set up particular kinds of institutions and structures that channel popular participation and representation. In other words, you create the environment in which politics occurs because constitutions are environments for political conflict and struggle. So setting these things up is the most important thing that constitutions do. What this means is that rights, we have a visitor, by the way, in the form of a bee, who's very interested in Mark's book. What it means is that rights are actually somewhat less important than the structuring of institutions. Rights are important as part of the structuring of institutions, but it's the structuring of the institutions and the creating of the playing field that's the most important thing in securing a republic over a long period of time. But it turns out that both Reconstruction Republicans, subject of Mark's book, and competitive authoritarians, people like Orban in Hungary, Erdogan in Turkey, and Trump in the United States, know this. Both of them know this, and both of them engage in techniques designed to structure the rules of politics to keep themselves in power. Both of them have Schmittian conceptions of politics. There are friends of the Republic, there are friends of union, there are friends of equal rights for white and black, and there are enemies of the same. So this talk is about the similarities and the differences between competitive authoritarians, who we see all around us today, including in the United States, and the Reconstruction Republicans. First, I'll start with the differences, because I think they're all important. The differences have to do with the aims of politics and also what I would call the reality principle. Aims, first of all. Both groups are seeking to tilt the playing field in order to stay in power, but they're aiming to stay in power for different reasons. The Republicans' goal is to extend equal citizenship and the right to vote in order to stay in power. They want to create a multiracial democracy. They want to secure equal rights and basic rights for everyone. They want to weaken Confederate power and establish federal authority. But when I describe these aims, it turns out these aims are actually tied to Section 1. Although Mark's book downplays the centrality of Section 1, it turns out that Section 1, at least symbolically, marks an important distinction between the aims of competitive authoritarians and the aims of Reconstruction Republicans. So even if the rights in Section 1 aren't, as Marx says, central to what the 14th Amendment did, they are central in understanding the aims of the 14th Amendment and the aims of the Reconstruction Republicans. So if I were to explain why are Stevens and Sumner different from Erdogan and Trump, I would point to Section 1 immediately. Okay. Reality principle. The reality principle, I mean, is that in politics, we respond to what is real or we respond to what is imaginary. Competitive authoritarians create crises. They declare emergencies in order to justify the use of force and to stifle opposition. Reconstruction Republicans, on the other hand, faced serious violence from former Confederates in the South. The emergency was real. The emergency wasn't feigned. The violence was all around them. They weren't trying to create emergencies in order to justify power. They were responding to emergencies and violence that existed. Competitive authoritarians create imaginary enemies. Reconstruction Republicans faced the problem of former enemies that they had just met on the battlefield. Those are the differences. Now I'm going to talk a little bit about the similarities. There are techniques that are similar for both Reconstruction Republicans and competitive authoritarians. First, weaponizing state institutions, changing the voting rules to benefit your party. That's Section 2. It's also the Reconstruction Acts. Restricting who can participate. That's Section 3. Taking off of the table certain leverage points that your political opponents might have. That's Section 4. You have political disqualifications and purges of the disloyal. You have the use of military and coercive force. All these things are described in Marx's book. Now I'm going to go a little further and talk about some other features of this period and their comparison to competitive authoritarians of today that Marx doesn't spend much time about, but I'm sure he would have things to say about. The first is control of the media. Obviously, competitive authoritarians try to get the media on their side, and they basically install friends in the media. This is what Orban did. This is what Trump has done successfully now. Did the Republicans have a media strategy? Of course they did. The media strategy concerned the mass media of their day, newspapers. They offered subsidies to Republican printers in the South. They patronized Republican voices in the media. They even engaged in various forms of military propaganda in order to fight the Klan. The use of the spending power. Competitive authoritarians used the spending power in order to coerce existing institutions of civil society and educational institutions. We've seen this in the United States. What did the Republicans do? Well, the Republicans also created schools, public school systems. In this case, instead of attacking the existing ones, they created new ones to make sure that Black people had equal access to education. The Freedmen's Bureau, a lot of the Freedmen's Bureau is about educational opportunity. They also created federal patronage in order to promote, to create their own civil society institutions. Of course, as soon as the Redeemer governments come in, they destroy these things. They destroy the subsidies to the Republican printers dry up, and they destroy the school systems. Many Black schools are burned, and the teachers faced threats of murder. But both of them are involved in media policy and in control of civil society institutions. What next? Religion. What's the role of religion in competitive authoritarianism? Well, in the United States, at least, the role of religion is the creation of a Christian nationalist hegemony in many different forms and guises. What was the policy of Reconstruction Republicans with respect to religion? Well, first of all, if you look at the Freedmen's Bureau Bill and other aspects of Republican policy, it was to promote religious freedom and also religious opportunities for Black people. At the same time, there's a darker side of this story because, of course, the Reconstruction Republicans are also the same people who are targeting Catholic education. They're also targeting Native American religion, and they're also targeting Mormons. What about ensuring loyalty? Well, competitive authoritarians purge disloyal. They require the bending of the knee and ways of ensuring loyalty. What did the Reconstruction Republicans do? The Reconstruction Republicans used loyalty oaths. The loyalty oaths were aimed at members of the legal profession, just as Trump aims at members of the legal profession today, and they were also aimed at other members of the profession. The Supreme Court, the United States Supreme Court, struck down these loyalty oaths in two cases, Cummings versus Missouri and ex parte Garland. So the loyalty oath strategy of the Republicans was not as successful as the strategy of loyalty oaths has been with respect to competitive authoritarians today. The judiciary. This is a less important part of Mark's story, but it is actually an important part of the story too, which I'm sure Mark would agree with. Competitive authoritarians tend to try to take over the judiciary and basically gets friends in high places that will cooperate with them. In the case of our particular system, Trump already has a federal judiciary, so he doesn't need to install a federal judiciary. He's already installed it in his first term, and now they're working more or less hand in glove with Trump's goals. In the context of Reconstruction Republicans, they faced a complicated situation because Lincoln had decided for purposes of union and unity to appoint both Democrats and Republicans to the Supreme Court, which created problems because some of the decisions of that court basically undermined the goals of Reconstruction Republicans. So the Reconstruction Republicans then later expanded the number of seats on the Supreme Court to install loyal justices. And then after the Democrats retired, they basically contracted the size. They contracted the size of the Supreme Court and then expanded the size of the Supreme Court, excuse me. I have to get that right. Down to 7 and then back up to 10 until they got an effectively loyal Supreme Court that would cooperate with the goals of Reconstruction Republicans. So what we can see here is that just from the standpoint of technique, there's a lot of similarities between what competitive authoritarians do today and what Reconstruction Republicans do. And if we expand past just sections 2, 3, and 4 and look at media policy, religion policy, the policy with respect to judiciary, and other aspects, the use of military force, there's lots of similarities. But the differences, it strikes me, are very important. The differences, it strikes me, are everything, in fact, in this story. And that's why I think Section 1 remains important. And even though it's not central to the strategy of the Republicans, it's important as explaining the justification for the strategy. One last thing before I go. Mark wrote another book on Dred Scott, also a very important book. And this book makes a number of important points, but one point it makes is to throw cold water on the idea that the difference between the court that decided Dred Scott and the court that would decide Brown versus Board of Education or Baker versus Carr, Reynolds versus Sims, or any of the other cases you think are the most important achievements of mid-20th century the United States have to do with technique, that they have to do somehow with making constitutional arguments in a better way, or a more responsible way, or a more legal way. And part of the argument that Mark makes in that book is that's just not true. That the court that decides Dred Scott uses exactly the same legal techniques and exactly the same forms of argument as the Warren Court would make in the middle of the 20th century, or your favorite court today would make today. That the differences did not lie really in technique. They relied in something different. They relied in political vision. They relied in political goals. And I think that's the lesson of this book for today. It's not the technique that distinguishes Reconstruction Republicans from the Trumpistas or the Orbanists. It's something much more important, which has to do with political values and political vision.
Hey, I'm Doni Gewirtzman. I teach constitutional law here at New York Law School. And this is actually the second time around for me discussing Mark's fantastic book. Rebecca and I were actually on a panel together discussing the book at Law and Society. So since then, a lot has happened. And so I thought in trying to engage with the book on a second reading, I would think a little bit about what's happened to our constitutional culture since January 2025. And once I started doing that, two concepts kind of jump out at me. The first is Article 5, and the second is constitutional hardball. Article 5 is on my mind because I'm reading Jill Lepore's fantastic book that looks at the history of popular amendment movements. And hardball because I'm on a panel with this guy, and his work in this area has been so influential. So the story Mark tells is a story of the 39th Congress using Article 5 as a mechanism with three overarching goals in mind, right? The first is to reward the righteous, right? To make sure that loyalists are in power and dominate the trajectory of post-Civil War politics. The second is to ensure that the Congress, rather than the president, rather than the courts, gets to oversee the trajectory of Reconstruction and the implementation and interpretation of the 14th Amendment. And third, they want to punish the wicked, right? They want to make sure that disloyal rebels and their sympathizers are denied political power to continue pursuing their policy agenda. And Mark describes this effort as largely successful, that the political world that emerges outside of the Article 5 process was one where regime change kind of worked. The nation was reunited, Republicans retained considerable political power, and rebel rule on the national level was effectively prevented. So how might we think about all of this in the context of a world where a contemporary political movement has similar aspirations, right? Seeking to use law to permanently entrench itself in power in the midst of a highly polarized political environment. And reading the book this time, part of me was like, wow, as a character, the 39th Congress seems so cute and quaint to me. Like, it felt like I was like watching Downton Abbey or The Gilded Age. And I was like, why do I feel this way? Because Mark does such a good job of making the 39th Congress come alive. Well, first of all, the 39th Congress is deciding to achieve their goals of rewarding the righteous and punishing the wicked through a largely obsolete mechanism, Article 5. That is not how business is done these days, right? You read all 800 pages of Project 2025, Article 5 doesn't show up once, right? Second, the 39th Congress really buys into this idea of legislative primacy, that Congress is going to be the central character in this story. It's the center of the political movement. They really believe that Congress is the institution that's going to chart the course of the future. It's legislative primacy all the way down. That is not how business is done these days, right? If you look at Project 2025, it is focused like a laser beam on the White House and executive power, right? The growth of the administrative state means that the president and the executive branch are absolutely critical to ensuring partisan entrenchment. And the executive branch is going to be completely critical in ensuring that the righteous are rewarded and the wicked are punished. Nobody in the 39th Congress is talking about the White House Office of Personnel Management as critical to achieving their dreams. Finally, the potential role of the federal judiciary in interpreting the work of the 39th Congress doesn't seem like it was really on their minds. The judiciary, in Mark's telling, almost seems like kind of an afterthought. From what I can tell, the 39th Congress isn't sitting up late thinking about what the Supreme Court is going to do with the 14th Amendment. And in part because the sections of the amendment they actually care about don't contain a lot of interpretive ambiguities. And they believe it's Congress, not the courts, that are going to steer this train. By contrast, as Jack already sort of mentioned, Project 2025 is really brought to you by careful efforts to sort of engage in partisan entrenchment with the federal judiciary that date back to the Reagan era. And indeed, partisan entrenchment in the judiciary in this context was absolutely critical. So in this way, it all felt very dated to me. But the underlying question, I guess, so that's sort of what I was thinking about Article 5. I want to kind of shift now to talking about hardball and what it means to play dirty when it comes to Article 5. In other words, was the 39th Congress playing dirty? Once we enter Article 5, what forms of hardball should be considered beyond the pale? At what point should we be clutching our pearls? And what political tools ought to be considered legitimate and illegitimate in this particular version of constitutional politics? And what does Mark's story about the 39th Congress tell us about where to draw those lines, right? What's an acceptable structure for political competition, to use Jack's terms? And why might the 39th Congress's version of hardball be okay and Project 2025's version of hardball be illegitimate? So I don't have an answer to this, but I had a bunch of thoughts. One is that it might be that the 39th Congress should simply get more leeway because the situation was sui generis. It's not an imaginary problem, it's a real problem. 2% of the American population has died. The threat of rebel rule remains very real. They're in a brawl with the president over who's going to control Reconstruction and who's going to dictate the course of the future. And they have this challenge of readmitting seceded states into the Union. Therefore, this doesn't have much to tell us about where to draw the lines because this is a DEFCON 5 emergency situation, right? And the situation necessitates political behavior that in other contexts we might think of as dirty pool. Another response might be that the 39th Congress was playing hardball the right way simply because they used Article 5 as opposed to other mechanisms, right? Article 5's version of constitutional change with its constitutional supermajority requirements, with its basis in the text, simply operates with greater legitimacy than other forms of constitutional change. And if you're going to use constitutional politics to change the rules of the game, to entrench yourself, this is the right way to do it, right? There's no such thing as dirty politics when it comes to Article 5. Another response might be that the 39th Congress was playing dirty because of their motives. And their motives were to make sure that their team won elections and the other team lost. And we should disapprove of all efforts to use Article 5 to achieve those goals. So, for example, if Democrats were to use Article 5 to amend the Constitution to get rid of the Electoral College and ensure that the winner of the popular vote always became president, and they did that because they believed it would structurally benefit Democrats going forward and mean more Democrats win future presidential elections, that partisan motive should cause us to clutch our pearls and be outside the scope of of permissible uses of Article 5 because of motive. Another response could be that the 39th Congress's actions were well within the realm of acceptable politics, regardless of their motives, because their proposal was facially neutral. They didn't single out another political party by name. And it left open at least the possibility that their political opposition could somehow win elections somewhere, right? In other words, you can use Article 5 for partisan entrenchment motives without violating the rules of hardball. But you've got to leave some room for continued political competition where it's conceivable that the other side could gain power in the future. So I don't know which of these things is right. And in some ways, maybe this is an entirely moot conversation because nobody is going to use Article 5 as a mechanism for constitutional change anyway. But hardball is very real. And so I hope at some point today we'll be able to talk about the rules of hardball and what Mark's book teaches us about that, and maybe sort of some guidance from the 39th Congress about what the rules of constitutional hardball ought to be. Thanks so much.
Thank you all for those very thought-provoking presentations. We open it up now. We have some time for back and forth, questions, comments, panelists as well, if you'd like to.
I just wanted to respond to Doni about some ideas of which actually, this might apply. Some things that could happen now that actually wouldn't require Article 5, that would be for partisan reasons. But what we have to understand is we really don't know in the future what the party is going to be. I mean, right? We're talking about the heroes of our story are the Republicans. They are the villains of the story today, right? So we don't really know. But one thing we do know that we could do, if the Democrats even were just to take control of the federal government again, would be to make Puerto Rico and DC into states. Now that's something that the Reconstruction Congress did that we haven't mentioned, but that Mark talks about quite a bit in his book, is the addition of Nevada as a state and Colorado, because they were going to vote. That was going to add 4 more Republican senators. I mean, that's why they did it. And I wrote a book about the guy who was in charge of that, James Ashley, and there's no question at all, like that he was on the committee of the territories. Very important, make these states into states for partisan reasons. Now, Puerto Rico, we don't know for sure that Puerto Rico actually would add 2 Democratic senators, because there are a lot of Republicans in Puerto Rico, but there's all sorts of reasons, including justice to make this happen, right? To make them into states. Size of the court. Oh, one more thing, apportionment of the House of Representatives, which is just completely ridiculously apportioned. Congress has control over that. We can make, no district larger than the smallest state, which is, I've lived in one of them, Vermont. Do you know how many people live in Vermont? About 650,000 people. And that's about the same as in Wyoming. So no district, no congressional district should represent more than that. And that would greatly amplify the number of Democratic seats in this country, in states like New York and California. And I think, so one, those things could be done without Article 5. And two, they should be done because even though they're partisan, because look at all the constitutional Democrats need to play constitutional hardball, I guess. I mean, and Jack's talked about this a lot. Obviously Republicans, if we're all upset about the non-seating of Grijalva, which I certainly am, and I think many of us are in the House right now. Well, remember when Mitch McConnell refused to take a vote on Merrick Garland? I mean, we need to be, yeah, sure, I'm a Democrat. I'm a lifelong Democrat. I mean, there's no doubt about that in my mind. I don't mind saying that. That's why I say we. But I think supporters of democracy actually need to take constitutional hardball very seriously. And I do think that is a lesson that we should learn from Mark's book.
Republicans refused to seat Democrats back in 1860 or 70 at some point.
Yeah, that's part of what happened here was the refusal to seat the rebels who were voted, and Mark talks about that quite a bit in the book as well, particularly the folks who were elected from the state of Tennessee, the newly re-entered. No, Tennessee was already. I'm sorry. Anyway, whether or not to allow the representation. Of course, Lincoln thought all the states were always states, but some people didn't. My guy Ashley thought they were territories because they seceded.
Yes, should I bring the microphone up or?
It's fine.
Yes, you can.
It's okay. Don't worry about it.
And you should yes, Yale.
Yeah, do you mind saying who you are?
So hi, I'm Gaurav Mukherjee, UConn. So I was curious about where you think the possibilities of constitutional repair lie after this administration. What does it look like? Is it constitutional? Is it statutory? Are there particular areas where we should focus, like, for example, reining back certain agencies like ICE? How should we think about reining in the use of executive power, some of which sort of originated, as some would allege, with the Biden administration continuing into this one? And are there any kinds of lessons that we can draw from places like Poland that you think might be relevant here? So like, what would a reconstructive agenda after this presidency, assuming we have a future Democratic administration, what would that look like?
I will make a Grabarian point. We don't know what the reforms are till the other party gets power. Once the other party gets power, the way in which they get power will tell us a great deal about the kinds of reforms that are appropriate in that context. Having said that, you should be aware that the eggs once broken cannot be put back. Executive power has expanded. If the Supreme Court gets rid of independent federal agencies, as I very much expect they will, it's going to be very hard to reconstitute independent federal agencies again where the president has the power to do it. It's very difficult for will be very difficult for presidents to bind themselves to the mast when they can so easily break the bonds of that mast, the bonds that tie them to that mast. The crazy way of putting this thing. So it seems to me that the most important durable reforms would be reforms to the representational system. You mentioned them, so I won't repeat them here. Those because those would change the incentives of representatives, and therefore, once you change it, they tend to be durable. This is what happened, of course, with both the reapportionment revolution in the early 1960s and the Voting Rights Act of 1965. People groused about them and yelled about them, but they created flipped incentives, and they created durable incentives for how politics was practiced. If you were able to do that, then of course you would obviously want new voting rights legislation to also flip the incentives for representatives. That would be very important. Notice these are all things having to do with Congress and the representational system, but I think that's actually probably a lot of what you have to do. I think that it's going to be very, very difficult to reform the presidency, precisely because the next president will want all the power that the previous two presidents had.
I guess I'll give two possible answers. One is a Levensonian answer, which is to simply say the structure, the underlying structure of the Constitution is so broken that any reform agenda is going to have to really revisit some core provisions and assumptions we have about the 1787 Constitution and the 1868 Constitution. But one thing I wonder, I guess, is whether any reform agenda has to think about reconstituting agencies. In other words, the deal with the administrative state that was originally cut took place in the shadow of Congress being able to assert a legislative veto, Congress being able to ensure some sort of independence from the president in the way these agencies operated. And the court is basically keeping the terms, the sort of structural terms of that deal, but they're just ripping out sort of key components of it and allowing the party to continue. And so I wonder if part of the reform needs to be a sort of like rethinking of how delegation works on Congress's end, and sort of revisiting the initial terms of the deal for how these agencies would be constructed in the light of the way sort of the Supreme Court has amended it in Chadha, as it will soon amend it by getting rid of Humphrey's executor.
I already gave my answer.
Okay.
Yes.
So I'm fascinated by, in Mark's book, he makes this distinction between the congressional Reconstruction and the presidential Reconstruction. And as far as, and I don't know enough about American history, but as far as I understand, we're talking the same time period. Right? While this 39th Congress is sitting, the president is actually taking actions. So it seems like there's a lot of executive power going on at the same time. And it's the interaction between those two that I find absolutely fascinating in terms of what was the possibility of the radical Republicans actually ever achieving their goal. There seems to be a lot of implication here that they actually achieved something. And I'm not so clear about what those achievements were, if in fact these important clauses, 2, 3, and 4, never really are able to gain traction given the changed politics of the South so quickly thereafter? Or do I just not understand the history?
Well, first of all, I really think there should be an opera about the 39th Congress because there was so much drama. I mean, who could ever even, true life is better than fiction, right? I'm just at the end of the war. This great transformational president, Abraham Lincoln, is assassinated, and then he is replaced by a copperhead Democrat, slave owner, racist, alcoholic, asshole. Well, I mean, let's just, right? And he's the president that's presiding over this effort to put together this country. I mean, part of what happened, Hans, is everything that Congress did, including all this 1866 Civil Rights Act, all the Freedmen's Bureaus Act, the Reconstruction Act, all of them were enacted by a supermajority over the veto of the president. The president vetoed almost all of these bills, and they were enacted over the veto. So this was a time when there was a strong enough consensus in Congress that Congress could could control over the president. But that was in part because the rebel states weren't represented in the Congress at the time, right, in the 39th Congress, right? And then you're bringing them back in. And then the other thing that's going to happen is, eventually the presidency is not going to be on your side, right? We got Grant, but then then the compromise of 76. And the
Your question is two questions. One is the interaction between the president and Congress during the period between 1866 and 1868 when Grant comes in. The second is the question of how, given that 2, 3, and 4 weren't very successful, why were they able to produce hegemony? And the answer is, so let's do the first one first. You explain it. Basically, Johnson is continually trying to throw sand in the gears, but they veto everything, and then they impeach him. And they impeach him. They impeach him until, yeah, and he tries to get rid of the war secretary. The war secretary barricades himself in his office, and they impeach the guy, and they're almost convict him, and they don't quite convict him, but it looks so bad, and they're getting near the end of his term that basically he just says, okay, fine, I'm not going to make trouble for you, and very much trouble for you, rather, in the last part of his term. And then, of course, Grant is about to take over. So the answer is it's a struggle, but it's a struggle the Congress wins, basically. So that's the first point. The second point is that, and this is the point Mark makes at the end of the book, well, they try a lot of different strategies. Some of them work, some of them don't work. It turns out that 4 actually is quite successful. Section 4 is remarkably successful. It takes these things off the table, and they don't become part of Congress later. 3, not so successful. 2, not really very successful. But by then, the Reconstruction Act, the second Reconstruction Act, 1867 Act, is quite successful in terms of creating biracial majorities in the South for Republican politics. And the territorial strategy, which is Nevada and Colorado, turns out to be quite successful. And that helps maintain Republican hegemony. Remember, the Democrats don't get a president in the White House until Cleveland, right? And then, of course, you get 1876, they might have, Democrats might have won, but the Republicans once again come up with a strategy. The strategy is basically the 15-person electoral commission, which the final vote is Joseph Bradley, who's a Republican stalwart, basically casting the final vote. So they're selling out. And selling out. And so, yeah, but the point is, the Republicans are constantly innovating in different ways, as you said, to play hardball. The Electoral Commission is a kind of hardball. Their territorial strategy is a kind of hardball. They don't just pass the amendments and give up. They keep trying different ways to basically stay in power. And they're remarkably successful. As Mark says at the end of the book, there's no secession. There's no second civil war. The Republicans dominate the presidency for most of this period. Really, they dominated until 1932. So you'd have to say, on the whole, it's a pretty successful story, even though from the standpoint of African Americans, it's not such a successful story.
So that's the question is, when they give the power back to the slave power, then everything's fine.
Yeah, it's the reconciliation. It's the reconciliation of Northern and Southern whites that ultimately stabilizes the Union. And it's done at the expense of African Americans.
So I think it's not successful.
Oh, Henry, you and I.
But I understand the
I'll wait till-
Okay, I'll go try and be quick. So I think it's notable with the impeachment of Andrew Johnson. Yes, it failed by 1 vote. And part of the reason why it fails is because they refuse to make it about his intervention, his interference with the Reconstruction Act. And, the parallels to today, the other thing is they're, of course, acting against the court, threatening jurisdiction stripping and court packing and saying, oh, to do judicial review, you need to get a supermajority in the Supreme Court. They don't have to pass these because the court backs down. But are those also lessons that we could have for a more muscular Congress? And was that, Andrew Johnson's impeachment, the great structural opportunity for like Congress really asserting its dominance over the presidency in this disciplining kind of function in doing an actually successful impeachment in that way.
I mean, and I just think that's a really good point. What if there actually had been an impeachment? If the impeachment had succeeded, maybe impeachment would now be a usable tool. I think that's what you're suggesting, right? But we find ourselves in a situation where the president is committing impeachable offenses every day and nobody even talks, barely even talking about impeachment. What if the, you know, and you probably know this, but John F. Kennedy wrote this book called Profiles in Courage, in which he celebrated the senator that did not vote to impeach.
I mean, I guess it's sort of short. I guess it's sort of short term and long term, right? My instinct is short term, it doesn't end up making much of a difference. The Republicans more or less end up getting what they want. And I mean, I'm not sure how much a successful impeachment at that point necessarily empowers future Congresses to do the same thing. Just because Congress is being so muscular in so many other ways that Jack just described, it just feels to me like impeachment is one of many possibilities the Reconstruction Republicans have available to them to get what they want.
Can I just add one more thing real quick? So my guy, who I keep mentioning, my guy, his name was James Ashley. He brought led the effort to get the 13th Amendment enacted in Congress, among other things. And he was a radical. He was a close friend of Stevens and Sumner. He really went off the rails on impeachment. I mean, he ended his career because he became obsessed with wanting to impeach Johnson. I mean, that's what really, he was so obsessed that he believed these in the first impeachment effort, this kind of crazy made up story about about Johnson being involved in being behind the assassination of Lincoln. I think he would, you know, he would definitely be a character in the opera.
Yeah, the situation with the current administration and then is not symmetrical. Remember, the Republicans have majorities in both houses. So you're not going to impeach this fellow.
I know.
Yeah, so, and you're not going to remove him. And I actually take the lesson of the failed Johnson impeachment to be a little different, which is that impeachment, if you couldn't impeach Andrew Johnson, then impeachment is not an effective method for disciplining presidents.
Yeah.
Essentially. On the other hand, the most important constraint of presidents turns out to be the 22nd Amendment, which is that the presidents can barely be constrained by anything, but they have to leave office. Now, if it turns out the 22nd Amendment gives way, then our goose is surely cooked. I mean, there are other things that can constrain presidents too, right? There's the economy, there are other kinds of things, but ultimately the internal checks on the presidency that were all designed in the original Constitution, most of them turned out not to be very effective.
Yes, I had a question. I also wanted to say that I see lots of people have questions. We are going to break for tea at 11, but we carry over the questions to the next panels. I'm going to save my question for the next panel then.
Or we could just take a bunch of questions at the same time, maybe.
Well, it's
Sure.
not a
So,
lot.
well,
Yeah,
can I just see, yeah, how many people have questions? So I think we go with our author.
One quick, one slightly longer point. It's very dangerous to extrapolate things from votes in the 19th century. So in fact, one reason we think the 13th Amendment was passed was because the New Jersey delegation was bribed. Long tradition. And in fact, there's a good deal of evidence now that the last vote was achieved by bribery, which just ruins all sorts of complex explanations. It turns out that the guy from Kansas was for sale, the guy from Maine wasn't. when, and by the way, this is also for those who ever do this, be careful counting 19th century votes. So, somebody wins the governorship of Ohio because suddenly a big vote in Toledo. This could be one person voting 10,000 times. And there's an amazing amount of statistical studies that do this, ignoring certain features of the politics. But it strikes me in thinking about tilting the playing field, Republicans and competitive authoritarians, there are three kinds of tilts, and it's worthwhile distinguishing them. In one sense, what you're really doing is rebalancing the playing field. That the standard Republican argument was true was that their Section 2 was a more democratic alternative to the Constitution. There was nothing unfair about what they were doing. It was the original system was the unfair system. All you're doing is allowing more adults to vote. A second thing you might do, I call recalibrate. Feel that is there are a lot of systems that are democratic and we disagree. Reasonable people disagree, which both you redo it. So you get the democratic system that most privileges your side. Even though some democratic theorists think you're just recalibrating, others say you're screwing up, but it's a reasonable choice. Now here, two things are of interest that I haven't seen written about at all. And I hope to write about a little bit, which is first, there's at least a movement in December among Republicans to also get rid of the Electoral College. I do know I'm seeing lots of petitions, I'm seeing articles on this. I don't yet know what happened to that movement. Second and more interesting is Democrats are saying, well, if you're going to go one person, one vote, the Democrats say there's a guy named Sandy Levinson who wants to get rid of the Senate. Now is our chance. Let's be fair. And of course, Republicans don't do that. So it may be what Republicans did is they took the undemocratic features of the constitutional order that were biased against them and fixed them, but retained the undemocratic features that they thought benefited them. Because at that time, the small states of New England and Democrats say everything about New England states that we now say about the underpopulated Western states. Vermont is okay, though. And the final way, the difference with autocrats is a lot of the changes really are through gerrymandering, things that just aren't democratic. So everybody, in some sense, changes the tilt, but it's important to understand the different ways you can change the tilt.
Okay, so 1, 2, 3. And we have about 15 minutes, so let's.
Yes, I was wondering if the panelists could comment on the prospects for peaceful, democratic, and constitutional presidential elections in 2028. And if you have suggestions on what citizenry and organizations can do to help facilitate that. We still have a few more years, so it's possible to lay some groundwork to help facilitate that, because as you all know, our current president has threatened to thwart the Constitution and seek another term. On and off, he's said that.
As good as mine.
Yeah.
Keep engaging in community organizations, keep the faith and keep working. Basically, I support democratic, support organizations that support democracy.
I'll just say one thing, which is whatever happens in 2028 is going to take place in the shadow of whatever happens in 2026. And so if I was trying to play out possible scenarios, one scenario I'd be paying close attention to is the president's aggressive use of the National Guard and what that means for elections in 2026. And so I almost want that piece of information before I talk about 2028.
Well, no, you can be quite certain that if he isn't stopped, he'll station the National Guard around polling places. And he'll have I'll be provocative, paramilitary organizations also armed, assisting the National Guard, because they will be friends of democracy. So one assumes that will happen. If he isn't stopped, of course.
Yeah, 2 points. First, very quick. The 22nd Amendment was, of course, the Republican revenge on FDR. And that raises very interesting questions about what we think today about FDR's breaching the British-style convention of 2 terms. Was his running in 1940 constitutional, in scare quotes, a good idea? But it is an interesting example of party dynamics and what you call ideological drift with regard to the fact that today it would be little d Democrats or big D Democrats who embrace the revenge amendment. But the other point, this combines Jack and Mark, I'm fascinated by the discussion of the impeachment because it's all about historical memory. And I'm glad that Rebecca mentioned Profiles in Courage, which I think is a truly pernicious book because it really did sell the story very successfully. Got a Pulitzer for it, that Andrew Ross saved the Union by courageously voting against the impeachment of Andrew Johnson. Furthermore, Sean Wilentz in 1998 testified before the House Judiciary Committee that the Clinton impeachment was just like the Johnson impeachment, that is a political vendetta, and they should be ashamed of themselves. And it does seem to me that it remains a very live issue whether one supports the impeachment of Andrew Johnson. I think it would have been a great idea, but I think that the historical memory that has been created of the impeachment is that it was, impermissible hardball. And thank goodness for Andrew Ross. And if you want confirmation for that, just read the martyred John Kennedy.
Or Sorensen, who actually wrote
or Ted Sorensen, whatever it is. But it does seem to me that inevitably we're talking about the construction of memory, the extent to which politicians construct the memory, like Kennedy, but also the role that academics play in doing this, like Sean Wilentz, and people who write the books. And then we can have an independent discussion of whether the Supreme Court is ever a reliable narrator about American history. And I think the answer is no.
Yeah, right. I mean, so important. I was kind of talking about that a little bit, the lost cause narrative that just that was promoted by historians in the Dunning School. That's really kind of resurfaced its ugly head in the anti-birthright citizenship arguments that some constitutional law scholars at reputable institutions are making. The narrative of the Reconstruction Congress being set on revenge and not caring really about rights or anything, or maybe being, it depends on, being alcoholics and, Grant being an alcoholic, John Bingham is crazy, We had an interesting experience last summer when Mark and I and a couple of other scholars were at this Society of Civil War Historians talking about his book. And there was a historian in the audience that raised their hand and said something like they hadn't read Mark's book, of course, but that sounded like what Mark was saying sounded kind of like that, if if the point is making, that Mark is making, this was all about remaining in power, that's kind of the argument that the Dunning School was making, right? And that's one of the reasons why I point that out in my talk, is that's really not, I mean, Mark is, what Jack said, right? Of like motivated by Section 1, motivated by enforcing the 13th Amendment. But I think you just make a really important point, Sandy, as always.
Oh,
yeah.
Let's take a question.
David.
Hi, David Simpson. I teach at New York Law School. I had a question that is, I think, tied to all of your comments, but motivated by the framework that Jack set up, which is the difference between aims and methods, and how really the difference in the aims is what makes all the difference in how we evaluate how you use these tools to stay in power. And I was wondering if you think, and I'd be interested in what Professor Graber thinks too, about how, if a judgment about values and how quote unquote good they are, which is always going to be contestable, is what is ultimately driving our thought process. Does the book and the events that it recounts tell us something about how we can evaluate which quote unquote aims or values are better? And one of the ways in which I wanted to ask this question is, does it make a difference, for example, as Jack mentioned, that the aims are in a constitutional amendment in Section 1, or at least you can point to one to say that these are the political aims that we're pursuing versus not? Is it a moral judgment from the standpoint of the present time of the person who's making the judgment? Are they connected? So I was just trying to figure out, so if, and I'm sympathetic to this, that it's always going to be a values battle, do we gain from the book and this time period an analytical toolkit to figure out how to make those judgments that is more nuanced than my values are better than your values, for lack of a better way of phrasing it?
No. Values are understood in hindsight. In other words, the United States, the way we understand the United States is now in terms of the new birth of freedom, the values of Reconstruction, which were hard fought for a very long period of time. And we understand the meaning of those events in terms of our understanding of the country we live in now and the truths. This goes back to FDR. We understand whether or not FDR was wise or to break the custom. It wasn't really a custom because Grant wanted to get a third term. And TR tried to get a third term, but the idea. Whether or not it was wise and appropriate in terms of the struggle against Nazi Germany. If you think Wendell Willkie would have been just as good at winning World War II than FDR, well, then you might have a different view. But if you think that FDR at that particular moment was the person most likely to win the struggle against a racist regime in Nazi Germany that had world domination as its goal, then you don't worry too much about the custom of two terms. So we imagine a different scenario in which the South wins the battle over historical memory forever. They don't win. They win the battle of historical memory for a very long time, but they eventually don't win it. But imagine they do. And the United States is understood to be a Christian white nation. And that's what it is. And that's what it always has been. Then the story of Reconstruction is told very differently, and the values of Reconstruction are told very differently. It is the success of subsequent constitutional struggles and political struggles for equality, racial equality in the United States, that produce the way we understand the memory of what happened during that period. It's no accident, by the way, that Foner's book, his famous book on Reconstruction, is written in the crucible of the events of the 50s and 60s. And so that's why the story of Reconstruction is told the way it is today. Remember, Du Bois had written the history of Reconstruction in the 20s, and nobody, well, not very many people paid attention to it. His construction of memory largely fell on deaf ears, at least with respect to white people. And it really is only the possibility of successful struggles for equality that make possible the telling of the story that allows us to judge Reconstruction in the terms we judge it today.
Yes.
Well, I was just going to say, I agree 100%. I think that's a really good point. But the battle's not over. The battle for memory is not over. It's ongoing right now.
3 minutes.
I'll be very quick, just raising for the rest of the conference, too, this historical memory of this being punishment, vengeance, revenge. Andrew Johnson with his veto messages saying the Reconstruction Acts are a attainder against 9 millions. And, 60 years later, the Klansman is going to be citing him, that these words are written in a quill of fire across the page of the nation and stuff. And so that's one place I might critique Mark just for his title and joining that Civil War historian. I'd love to hear this conversation more because it is, the Republicans are, and I, in my research, I'm arguing that they are debating the terms that this is punishment. It's Section 3 itself, the most seemingly punitive, it's not supposed to be punishment. And they take the disempowerment and Black suffrage itself is the greatest vengeance on the South in their understanding. So fighting that terms that it was not punishment, even with something like Section 3, and they have all these constitutional arguments, I think is important.
Thank you all very much.